Lance, you know, this type of thing that you don't think about until it happens to you, and whether you're an employee or an employer, if someone is injured on the job or even driving a car, you know, for your company or while in their employ, what's the first thing you want to do? Because it's be a good idea to think about this ahead of time instead of when it happens and you're maybe injured or shook up. Or
let's talk specifically about what an employer should do.
Okay.
An employer, if they have an insurance, workers' compensation insurance, their contract obligates them to notify their insurer within a very short time period. If they don't do that, the insurance company could take the position that they failed to timely notify them and deny coverage. So it's very important for an employer, when someone is injured in the course and scope of their employment on their job site, to notify their insurance company. With regards to an employee, it's as well important to notify their employer, and they have an obligation to do that within 30 days of an injury. Typically, an injury is something that an employee knows about right after it happens. It's a sudden and unexpected event that causes an injury. And if that occurs, then they have to notify their employer immediately, and I would suggest right after it happens. There are very few instances where there's an injury that the employee would not have known after the accident, but after going to a doctor should have known after seeing a doctor that it is related to his work, and he's got 30 days to notify his employer of that condition. But that doesn't happen very often. Usually it's a traumatic event, and if that occurs, the employee should go straight to his employer and say, this happened.
So as rare as that would seem, I would think it would be an instance like somebody that slipped and fell and, oh well, I'm fine, and get up and keep going, and then find out the next day or sometime later that, boy, I really did pull a muscle. Or
that happens, but even if you have some type of accident and it's not a real big deal, you should still tell people. That way it's recorded, people are aware of it, and an insurance company can't come back and say later you failed to adequately notify your employer and therefore were denying coverage. So the best advice is just to notify your employer of any incident as soon as possible.
Because then the information's fresh, you remember what happened, maybe there's other people around that could have seen it happen, or
exactly,
all the things that may have caused it. Or
exactly.
So it's the employee's responsibility to notify the employer, and it's the employer's responsibility to notify the insurance company. Now, who is not required to have work comp insurance?
If you have less than 4 employees and you adequately notify your employees that you do not have workers' compensation coverage, you can be exempt from providing workers' compensation coverage. All too often, the employer does not do what's required by statute to not have workers' compensation coverage, and they become obligated to provide those benefits just as if there's an insurance company present. A workers' compensation attorney representing an injured worker can file a claim against an employer just as if he has coverage, and the employer has to pay those benefits.
Out of pocket?
Out of pocket. That
Wow.
can end up in a judgment that can be enforced in circuit court, in a judgment obtained against that individual, the employer, for the benefits that the injured worker has to have or is eligible for as a result of that injury.
So even if you have 4 or fewer employees, it really makes sense to get workers' comp insurance?
If you don't dot your I's and cross your T's with regards to how you exempt yourself from coverage, then you will be obligated to, as if there is an insurance company and it's the employer that's going to have to provide those benefits.
Okay, very good, interesting. Thank you, Lance.
Thank you.